This is TWiT.
I have a card for our special guest. Stacy broke her toe last night. So Catherine R. Gellis, Esquire, is here from cgcounsel.com. Former internet professional webmaster, now assisting clients with legal issues related to the digital age. Hi, Cathy.
Hello.
You're in D.C.
I'm in D.C.
And why are you in D.C.?
You know, I guess if you're a lawyer, it's good to go where it gets made sometimes. So, see it up close.
You went to the sausage factory in person.
I went to the sausage factory, yes.
And I understand that today you were in the Supreme Court.
Yes, there was an important copyright hearing at the U.S. Supreme Court, and I wrote an amicus brief in the case, and it's interesting to kind of see it live as they talk about really important issues and what they're going to do about it that are going to affect all our lives.
I bet you Cathy knows how to pronounce certiorari.
Certiorari, I think.
Certiorari, okay. See, I knew I knew
Amicus or amicus? I think I've been saying amicus. It's amicus.
Amicus?
I think it could be either. Some people seem to say it's the way that I don't pronounce it, and they're just wrong. So I think you can have whatever your own natural accent provides.
Last time, Cathy...
Does doing a brief get you a ticket into the Supreme Court?
No, it did not. I had to stand online. I got there at 6 a.m. and they only took 19 of the Supreme Court barred people, but I got in. But my friends who got there at 8 a.m. didn't. In previous years, I'd actually camped out for a case. I camped out for Aereo because there were line sitters and it was so competitive that we were afraid that we wouldn't get in. But then after that case, Justice Scalia said, enough of this nonsense. You're licensed by this court. Stop hiring line standards, so you had to do your own standing, and lawyers are lazy, so we just
so
show
you're
up
barred
that
for the
morning.
Supreme Court? Have you argued?
I am, which
Court?
is I could in theory. It's also how I'm able to file amicus briefs there. If I weren't barred in that court, I couldn't be the attorney that did that.
Oh, so the Onion is barred at the Supreme Court?
So they had to hire somebody.
No, the Onion had counsel that was barred in the Supreme Court to file it. I mean, they may be barred by the Supreme Court at some point, given, after that brief, but
we should probably explain.
Not barred in.
Barred in means it's like passing the bar. Is there a test? How do you get barred into the Supreme Court?
No, so you get licensed by state, and they're the ones who, in theory, are doing the full test of moral character, and in theory, your competence to be a lawyer. That's what people take the bar exam for. Open question about whether it's actually an effective test of competence, but that's what they do. But then different courts in the federal system do their own admissions if you want to practice before them. I think the individual district courts, and for them, you sometimes just need to pay a fee. Sometimes you pay a fee and add a little bit on a form. Sometimes you need references. And then for the U.S. Supreme Court, it's basically the same thing. It was mostly a form, but you had to have been in practice, I think, 3 years, although maybe 5. And you had to get people that signed your form kind of as movants. So like they moved to have you admitted in the U.S. Supreme Court. So it's a little more formal, but basically all you have to do is be a lawyer, not get in trouble, and fill out a form. But if you do get in trouble after, you can get kicked out. My understanding is that Bill Clinton, after he was impeached, got kicked out of the Supreme Court bar because they didn't like that nonsense. He wasn't of good moral character, etc.
Do you get a bumper sticker or anything? You get a little something to put on your desk?
They sent a certificate. A lot of the courts sent a certificate. My certificate, I think, if I remember, is sort of large because it's the U.S. Supreme Court. But the interesting thing was there were 2 people I had to get signed. One, I think, was a reference, but the other was called the movant. And I got my con law professor from law school, the really scary kind of paper chase con law professor. He signed mine. And for some reason, that name, then when I got my certificate, his name is like, and the person who moved you is, and so my con law professor is on my Supreme Court certificate for having moved me into the Supreme. That was kind of cool. I actually thought that was like an accident. That was a nice accident that happened. So yeah, mostly paperwork, but sometimes lawyering is all about the paperwork. So, you do paperwork.
You chose it.
Right. Well, not for the paperwork, but yes.
So why you're there for the Andy Warhol case? Tell us why you're there.
So there were a couple of cases, losing track of time now. Time, how does it work? A couple of years ago, a case in the Second Circuit coming out of New York, and a case also that was similarly troubling that ended up coming out of the Ninth Circuit. What these cases essentially did was decide that subsequent works didn't count as fair uses, and if they didn't count as fair uses, then they would be infringing copyright. So both cases ended up, they both won at the district court, where both of these subsequent uses that used another work were found to be fair uses of the work. In the Ninth Circuit, this was the case involving the Dr. Seuss mashup with the Oh, the Places Will Boldly Go, where somebody wrote a book that took Star Trek imagery and combined it with Dr. Seuss motifs.
Bad taste, but not illegal.
Actually, it was really well done.
Oh,
actually,
good.
I think it was quite clever. Like, it kind of really united those things in actually a really meaningful way that added new meaning, and that's important. We'll get back to new meaning. Meanwhile, there was also a case in New York, and this was less recent, but there had been a photograph of Andy Warhol taken in like the early 80s that Andy Warhol then ended up adapting and turning into the really famous Prince, Prints, of Prince, Prince. This is a very.
It was a picture of Prince, not Andy Warhol. It was this picture from the 80s. Lynn Goldsmith took the picture, and this is Andy Warhol's portrait. Even before then, wasn't there a AP sued Shepard Fairey over this famous Obama Hope poster because an AP photographer took the picture? That one was settled out of court.
Yeah, that one hit a weird roadblock in discovery and never really got decided on the merits. Everyone kind of bailed out of that case. So it wasn't really figured out. But there was an important case in, I guess, the late 80s called Campbell versus Acuff Rose. And this was a really important fair use case that the Supreme Court considered. This is the one where, and now I'm blanking on the name, was it Beast? There was a takeoff of Pretty Woman. That was a very raunchy takeoff parody.
It was
Two
Live Crew, yeah.
Two Live Crew, yeah. And that was a really important case because Roy Orbison or his estate really didn't like that. It was, it's a kind of crude song, and they didn't like they called it infringement, and they didn't like that it was messing with their song. And the Supreme Court said, no, we really need to create space to have new meanings and new things come out. This has to be a fair use. But, that case can really only reach the merits for what the facts of that case were challenging it for. But it had language for how to think about a situation like that. And then it had some other helpful dicta that sort of helped guide courts in the future to find that other subsequent uses, even when it used identifiable source works, could still be considered fair use.
One of the
so
tests
in theory, that's what it was.
in the Two Live Crew case was, did it cause commercial harm to Roy Orbison? Would it cause loss of sales to Pretty Woman? And the Supreme Court said it's extremely unlikely.
I mean, that is true. So fair use built into the statute has a multi-factor test. It's not necessarily exhaustive, but there are 4 factors that used to be thought of at common law, but then they kind of baked them in the statute when they updated the copyright statute for the 1976 Act. And I should pull them up. I
have them in front of me.
But okay, so there's 4 factors that you look at, and you kind of analyze, okay, so you have the original work, and then you have the subsequent work. And let's say especially that the subsequent work is, somehow hearkening back in an identifiable way to the original. That may still be fair use, but you're going to decide if it's fair use by thinking through those factors. So that's great, but it's also really, really, really fuzzy.
In fact, fair use is, as somebody once said, merely the right to hire a lawyer. That
Lawrence Lessig said that.
Larry Lessig. So the 4 cases are the purpose of the use, whether it's for commercial, for instance, or a nonprofit or educational. That's number 1. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion used. And number 4, the effect of the use upon the potential market or value of the copyrighted work. And it was that 4th test. The Supreme Court said, yeah, you didn't cost Roy Orbison anything. I'd heard also that the parody defense. So, for instance, when Weird Al makes a parody song, it has to parody the original maker of the song. It can't be devoid of that. It has to refer back to the original.
Well, that's what we know more for certain.
Yeah.
Because some of it has to do with commentary, like fair use is a theory of vindication of First Amendment rights to have free expression, and copyright in theory impinges on that. But one of the ways that copyright is not incompliant with the First Amendment is to make sure that you still have free expression around it, and fair use helps preserve the ability to freely express other things. It's there to help vindicate that other expression can happen. So if you're commenting on the original, then that tends to be more clearly, and there's precedent, I think, on point about this to say, well, okay, we can't make that illegal because then we'd have a First Amendment problem. But that doesn't necessarily mean that other types of expression couldn't be legal too, but sometimes it's not tested. Or then you get these cases that I'm describing where all of a sudden, like, the district court looked at them and looked at these subsequent uses and said, yes, they're fair use. But on appeal, the appeals courts said, nah, we don't think so. They basically reran the 4-factor test and reran it in a way that looked at the subsequent use and said, nope, we don't see clear to do this. This must be infringing. And so this case at the U.S. Supreme Court was, hang on, it doesn't look like the way, and I bring up the Ninth Circuit case because it was similar and I think really troubling, and in a way that I think highlights what was troubling about this one somewhat more clearly. But in this particular case, where the Second Circuit said, nope, Andy Warhol must have infringed essentially when his prints were not fair use. All of a sudden, there's a question about, is that decision right? But also, what would it mean for any subsequent uses? Because the logic they used in running those 4-factor tests would shut down an awful lot of other expression that happens to build on other works. And you really need to be able to build on other works to be able to say new things. So that would create a really chilling effect. So what was before the court today was, hang on a second, did the Second Circuit get it right? And they were talking most particularly about the 4th factor, but also the 1st factor with the purpose and character of the work, and questions about whether the new work brought new meaning. And if yes, what is the significance that it did bring new meaning, and how should that affect
Why did this come so many years after?
Let me give you the facts of the case so you understand that.
Thank you.
The picture was taken in 1981 for the by a photographer Goldsmith before he was famous. 3 years later, Vanity Fair commissioned Andy Warhol for a series of 6 silkscreen prints as well as 2 pencil sketches based on the original photograph and published them. However, the Vanity Fair had obtained a license from Goldsmith, but she said she was not aware that Warhol created other images that were not licensed. In fact, she only became aware after Condé Nast used a different image, one she had not licensed, as part of a 2016 Prince tribute immediately after his death. Of course, Warhol died in 1987. The relevant works are held by the Andy Warhol Foundation, which had given permission to Vanity Fair to use the image in 2016, but Goldsmith was not created. So that's when she sued. In 2019, a federal judge ruled in favor of the Andy Warhol Foundation, saying the images were transformative because while Goldsmith's photo showed a vulnerable human being, the Warhol-Prince depicted an iconic, larger-than-life figure. Actually, that sounds like they were ruling against the foundation. I think that NBC got this one wrong. Ruled against the foundation. The foundation then sought Supreme Court review after the second court ruled in favor of the photographer in March 2021.
Wait. Goldsmith, The foundation holds the Warhol version, and they were saying the Warhol version was, in fact, a larger-than-life image. So they were in favor of the foundation against Goldsmith.
Right? Yes, you're right. And then in under review, the Second Circuit said, no, the photographer wins. The appeals court faulted the district court for focusing on the artist's intent, saying that the judge should not assume the role of art critic.
That's the interesting part, yeah.
Yeah, it's interesting. Instead, a judge must examine whether the new work is of a completely different character to the original. It must, quote, at a bare minimum, comprise something more than the imposition of another artist's style on the primary
But that's
work.
part of the comment.
So
that's a nonsensical.
that takes us to the Supreme
decision.
Court. Kathy, what did your amicus brief say?
Our amicus brief, I did this for the Copia Institute, which is the think tank half of TechDirt, is we base 2 big points. One was to remind the court that copyright law has to comport with the First Amendment. So the first half of the thing was talking about, if copyright law is all of a sudden saying no to free expression or somehow not helping further the progress of arts and sciences, which the Constitution says is what copyright is for, then you've got a problem. And so if you're looking at a case where all of a sudden you're saying no to further expression, that suggests that if that's the way copyright law is being interpreted, you have a problem. And then we talked further about, the reason I talk about the Dr. Seuss case is I was so alarmed by that case in the Ninth Circuit, basically saying, how dare you create something new that the original copyright holder for all Dr. Seuss works didn't license you to do, and just how foreclosing that would be if the original copyright holder could say no to things. And we also pointed out that, it's different in this case, in this Warhol case, where Warhol, the subsequent user, is dead and the photographer is still alive. But in the Dr. Seuss case, it was the other way around. The estate of a dead person was saying no to the new creative work of a live person. And if that's something that copyright law says is okay, I think we have to think twice about it, especially given the really long terms that copyright has. That's a problem, I think, if that can happen. And so we pointed out how that fact alone helps illustrate what happens when you chill the ability of other people to rebuild things and create something that might never have existed. If the original creator, a dead person is never going to do it, but maybe they wouldn't have licensed things anyway. The Ninth Circuit sort of took the view of as a copyright holder, they could have decided to license to a Star Trek mashup or a Mickey Mouse mashup or any sort of other mashup that they wanted that they chose to license. But either nobody knocked on their door or they weren't interested in doing the deal. So none of those mashups happened, especially not one with this particular expression and charm, until this artist independently thought, I can make a fair use by combining these two things and creating something new. The district court said that looks good under the 4-factor fair use test and relying on the Campbell versus Acuff-Rose test. And then the Ninth Circuit just sort of said, nope, you're too greatly cutting into the exclusive rights of the copyright holder. And that's something that came up today because copyright also, one of the exclusive rights that a copyright holder has is to control derivative works. And there's a tension in the Copyright Act between a derivative work and the fair uses of works, which may be transformative in their meanings. And so what is the difference between a transformative work and a derivative work? Because one would be legal as a fair use and the other one would not. And this is actually, when I was learning copyright law, was really confusing and made me very frustrated. How do I learn this? How do I get my head around that tension? And that tension is sitting in the statute. But what the Warhol side was arguing a little bit is that the text does sort of say that the derivative work right is subject to fair use, the fair use rules as well. And then they kind of point out what would it mean to subsequent free expression because everybody somehow references a source work somehow. What would happen?
Walt Disney didn't base Snow White on nothing. And of course, famously, Walt Disney then copyrighted it so no one else could make a Snow White. The Brothers Grimm, I guess, didn't get their day in court. So today was the day for oral arguments in front of the Supreme Court. That's why you were there. Among other things, we learned that Clarence Thomas was a Prince fan. Who knew?
But not necessarily anymore, only on Thursdays, apparently. So the thing unfolded where he started with a hypothetical of, let's say I were a Prince fan, and then he says under his breath, which I was back in the 80s, and then somebody, I think Justice Kagan, kind of piped up, and no longer. And so everybody in the room laughed. And then he kind of pulled himself together and said, well, only on Thursdays. So on Thursdays, he's
So
he's still a Prince
it's interesting because you don't usually think of the Supreme Court as having any banter during these oral arguments, but they do actually.
You know, one of my takeaways I was telling somebody is I'm actually really glad I went as somebody who practices before the court, because I've been really, really angry with them, and for good reason. Their jurisprudence has been frightening. The way they've been comporting themselves has been disturbing. They've really sort of taken themselves down a notch in esteem and what they're worthy, and also, but what happens to our system of law if it's not? Like, you know, we talked at the beginning of the show about what it was like, you know, getting admitted to the Supreme Court bar. The first thing they do before every oral argument is there's some people who actually get admitted on the spot. Like their papers are all in, but then the court verbally grant that their motions be granted, and then they're given the oath on the spot, and there's like all this dignity built into it. So when they're kind of cutting corners and changing the rules and this, then the other thing, it's really heartbreaking, almost on a religious level of like, no, this is something we really kind of revere and need to revere. So my attitude has been very, very cynical, growingly cynical. I kind of appreciated being in the room and being reminded of the human beings. I mean, I don't think it redeems the systemic things that are so troubling, but I think it made me not hate them quite so much. And I think I needed to be reminded that these are people, and that my skills and my writing could still potentially speak to these people. They have ways of thinking about things, and my job as a practitioner is figuring out how to convey something that they can hear.
They're not gods. Although they have godlike power in some cases.
Yeah. But I was actually surprised by the report. They, you know,
they seem to be collegial. They seem to get along.
They did.
Yeah.
Interesting.
Cathy, I saw a tweet today, and I couldn't get in the context of it, so I just saw somebody come, oh my God, the government's arguing against fair use.
That's not true at all.
It's not true at all. Right?
It's a debate about what is fair use, right?
Splitting the baby a little bit, I think Jeff is actually more correct.
Really?
They basically took the photographer side, and their model for how they did it, I think, was troubling. It's been too long since I've seen it, but Mark Lemley kind of summed it up in 2 lines of like, if this is what they were arguing, some fundamental thing is missing. But overall, and I can't remember what that was, even though it was pithy and correct, but I think the model that they want is really one that closes the door on an awful lot of fair uses, and they were explicitly taking the side of the photographer and not on the side of the derivative work. And I think some of the biggest argument was, well, because one of the problems is that this is involving photography, and photography has such a limited runway in terms of how it can be monetized, and it's so easy to copy. And photographers were writing like really panicked amicus briefs saying like, if you grant this as fair use, photography is dead. And I think that might be overstating it. And I think there's still monetization models and this, then the other thing. But it is a very difficult medium to protect, especially if you have expansive fair use. So that's true. And I think the government's position was, but we've got some licensing models that provide monetization that creates income. And if you have too much fair use, then those licensing models will fall apart and the economics of photography will change. And I can see the alarm in the government wanting to sort of, protect photographers, but I think they're trying to protect the photographers at the expense of photographers themselves, because it's at the expense of anybody who would like to make subsequent expression. And sometimes that's photographers. Everybody needs fair use to be able to sort of speak, because we always reference in some way something that came before. And the longer a copyright term, the more expansive a copyright seems to be, the more exclusive rights and the more powerful those rights, the harder it is for anybody to speak. And I think that's dangerous. I think they're taking the wrong view and needed to take a more global view of, we got to keep people talking, and if we want to keep people creating.
Hey, what's going on, everybody? I am Pruitt, and I am the host of Hands on Photography here on TWiT TV. I know you got yourself a fancy smartphone, you got yourself a fancy camera, but your pictures are still lacking. Can't quite figure out what the heck shutter speed means? Watch my show. I got you covered. Want to know more about just the ISO and exposure triangle in general? Yeah, I got you covered. Or if you got all of that down, you want to get into lighting, making things look better by changing the lights around you. I got you covered on that too. So Check us out each and every Thursday here on the network. Go to twit.tv/hop and subscribe today.